Welcome to today's program titled The Second Trump Administration, Anticipated Key Priorities and Changes for Labor and Employment Regulation and Enforcement. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down, as it will not be reread, and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP, for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our moderator for today's program, Camille Olson. Camille, please go ahead.
Thank you so much, Kate, and welcome everyone to today's program. My name is Camille Olson, and I'm a partner at Seyfarth, based mostly in the Chicago and LA offices. I am also Workplace Policy Counsel to numerous global and national business, industry, and human resource associations. I will be joined today in this webcast with two of my partners. First, joining today is Rachel C. from our DC office. Rachel is Seyfarth's subject matter expert on AI technologies, focusing on risk management, governance, and regulatory compliance. She also has 12 years of experience in the federal government, where she led enforcement policy and digital transformation initiatives. She also previously served in several roles at the EEOC, including most recently as an EEOC Commissioner's Senior Counsel for AI and Algorithmic Bias. I am also joined today by my partner, Leon Rodriguez. Leon is a founding member of Seyfarth's Immigration and Compliance Specialty Team. Leon is a former federal prosecutor and leader of multiple federal and local agencies, including the Director of U.S. Citizenship and Immigration Services and the Director of the U.S. Department of Health and Human Services, Office for Civil Rights. Leon chairs Seyfarth's government relations practice. With that, I'm going to turn it over to Rachel to get us started. Rachel?
Rachel, you're on mute.
Inauspicious start. Hopefully you can hear me now. I'm going to assume you can hear me now. Excellent. So let me try to level set here as we contemplate what changes or not changes are coming up in the second Trump administration with Republican control of both the Senate and the House. Let's skip ahead to a couple of slides and let's start with talking about the EEOC. So part of my own background before coming to Seyfarth and focusing my practice on AI risk management here was I was at the EEOC working as career staff in the Office of General Counsel, helping to run that litigation program. And after spending some years as Assistant General Counsel for Technology at the EEOC, I worked for the chair and one of the commissioners in both policy and management roles. So some of the arcana of the commission on what is the interaction between the commission itself and the general counsel now becomes highly relevant for what is in store here. So I guess part of what is in store in the second Trump administration involves digging into some of this arcana and what is the normal course of operations and what are the powers of the politicals to influence what the commission actually does. Let's go to the next slide. So I think my prediction, because President Trump doesn't have a lot of other options here, is that on day one, he's likely to appoint Andrea Lucas as the acting chair. Currently, the commission has three Democrats and one Republican, who's Andrea Lucas. And when the administration changes, the commissioners, their terms don't expire. They serve under Title VII. They serve for set terms. So, assuming all of the commissioners serve out their entire terms, the Republicans wouldn't have a majority on the commission until July of 2026. That is a while. And so if you think back to the start of the Biden administration, the Democrats didn't have a majority on the EEOC until 2023, until the end of 2023. So there was Republican control. Yeah, the Republicans had majority votes on the commission, even though the chair, Charlotte Burrows, was a Democrat. So assuming all of the current commissioners serve out their entire terms, we wouldn't have Republican control of the commission with those three votes, with that majority vote until July of 2026. Now, is it possible that President Trump will attempt to fire the commissioners or to assert somehow that Title VII's restrictions on the president's ability to fire the commissioners somehow makes this structure unconstitutional? These theories have been floated. It is possible. But what we're going to talk about here is we're going to talk about what regular order looks like. That if we have a transition on the commission that looks like the previous transition. So under that transition, we'd have Andrea Lucas as acting chair without a Republican majority. So let's go to the next slide. So because Andrea Lucas has been serving on the commission for a while, we have public information about how she thinks about the business of the commission. In addition to all of her public speaking and all of the things that she's talked about, her priorities. And like most Republicans here, I think there is broad bipartisan support for the day-to-day operations of the commission. And I think with all of the conflict that we see in today's environment, it's easy to lose sight of the fact that there's broad support for the day-to-day enforcement and litigation activity of the commission. One of the insights that we have is just the pure data of what does the commission vote on. Under the commission's current voting procedures, the entire commission votes to approve, to initiate some litigation, not all, some, but they also vote to approve all of the commission's amicus filings. So if we look at the last fiscal year, the fiscal year which ended at the end of September of 2024, we see that Andrea Lucas voted to approve 92% of all of the litigation recommendations presented to her for a vote. She voted to approve 71% of the amicus filings and 54% of what the commission calls non-litigation recommendations. And those non-litigation recommendations, those NLTs as we call them, right? Those include rulemaking. They include things like some procurements, some large procurements, as well as things like interagency MOUs. So there's a lot of things in that 54% that are non-controversial, but there's also things that you see that's where some of the controversy lies. The other thing we know about Andrea Lucas is that she frequently voted across party lines, that she frequently has voted to approve things that when she had fellow Republicans on the commission, she voted with the Democrats to approve that litigation or those other kinds of filings. So, in terms of thinking about what regular order under an acting chair, Andrea Lucas, looks like, I think we have evidence, we have the numbers that show that in the past, she's supported the regular activity of the commission. Let's go to the next slide and talk about some of this other structural things going on here. So the text of Title VII says that while litigation that the EEOC does is conducted by the General Counsel, it is initiated by the Commission. That's in the text of Title VII. So while President Trump could fire the EEOC General Counsel and the Senate could confirm the replacement, however fast that happens, for various kinds of litigation for that doesn't fall within the existing delegation. I should explain what that means. I will explain what that means, but the commission has to approve litigation before the general counsel files it. Under the current procedures, the commission has delegated to the general counsel including career staff in the absence of a GC, the ability to file some kinds of litigation on their own. But big cases, the big systemic cases seeking to overturn existing precedent or that's going to gain a lot of publicity, those kind of cases the commission has reserved to itself and said, we want to vote. Our procedures say we will vote to initiate this litigation. So let's briefly go to the next slide. I'll come back to this point. So one of the things that the chair can do, even without a majority, the chair or the acting chair can prevent litigation from being brought to the commission for a vote. The chair controls the agenda. The EEOC chair controls the agenda under current voting procedures. I'm using these words carefully, right? So the chair can control what gets brought to the commission for a vote. If she doesn't like the litigation that the GC's office or career staff in the GC's office are presenting to her, acting chair Lucas could simply not bring that up for a vote, and thus it wouldn't be filed. Likewise, amicus filings in the courts of appeal, or even filings of or the district courts. We saw some very interesting, a very interesting district court amicus brief this year. Those filings must be approved by the commission under current procedures. So the chair could simply defer to bring those in front of the commission and stop that from being filed. Let's go back to the previous slide real fast. So the routine enforcement and litigation, I think there's bipartisan support for that to continue, and that I would expect that under regular order, acting chair Lucas would bring would bring litigation that she agrees with before the commission for a vote, and we'd have bipartisan, probably unanimous approval for it. But one of the questions, one of the things to think about under the second Trump administration is, with all of the rhetoric and expected activity on cutting government, on trimming government, what does staffing changes and having restrictions on budget or having a budget cut mean for the EEOC's enforcement and litigation activity, even the routine bipartisan supported enforcement and litigation activity? So if you've been paying attention to some of the goings on at the EEOC, they had budget problems, they had budget challenges even under President Biden this year. I think it's safe to say that we shouldn't hold our breath. We shouldn't hold our breath expecting the EEOC to receive more money under President Trump. I think there will be pressure across the board for all programs, all of these kind of programs to face some either belt tightening or at least no increases. So what does that mean for the EEOC's ability to execute on its regular, non-controversial enforcement and litigation activity? Less people, potentially fewer people, as well as a pressure, like we see in the rest of the federal government, for certain kinds of policy making people, career officials in policy making roles to become dismissible at will under something called Schedule F. Let's go to the next slide again. So whatever the chair's ability to push through career staff resistance or to reassign executives, how well she might execute on that and how much that might be subject to challenges, none of these personnel actions will happen overnight. And until we have the personnel policy changes and the legal challenges to those personnel policy changes get sorted out, potentially going up to the Supreme Court, we have existing career staff either continuing their job or simply that activity being tightened up. So I don't think we should expect things to just come to a grinding halt at the EEOC. I don't think that's likely to happen. I think it's important to focus on the probability that routine enforcement and litigation will continue. Now, what else can the chair do without a vote? What else can the chair do without a majority to force through things over objections? Well, first, she has the bully pulpit. The EEOC will, that acting chair Lucas would have the bully pulpit and the ability to issue press releases and say, well, this is what I think as the EEOC chair, as the acting chair, what the law is or what it should be or how I think what direction we should be sending it in. And you can see previous EEOC chairs use and commissioners using that platform to interesting and sometimes gaining lots of attention over it. Andrea Lucas has used the bully pulpit as a commissioner to issue warnings to corporate America about DEI programs, talking about her interpretation, her concerns that existing corporate DEI programs violated the law. And so, I would expect acting chair Lucas to continue spreading that message with greater force, with the force of this is now the leadership of the commission talking about that. The other thing the chair or the acting chair can do on her own authority without a vote is to issue technical assistance. So technical assistance doesn't get deference. It is not formal guidance. It is not formal rulemaking. I think the most widely known EEOC technical assistance is the document that the EEOC put up and updated very frequently during the COVID-19 pandemic under the Trump administration, which advised employers about all kinds of issues on COVID-19 and how it intersected with existing employment law, like Title VII, like the Americans with Disabilities Act. Okay, let's talk about what requires a vote. Let's go to the next slide, please. So things that must have a vote and thus without a Republican majority are not going to be moving forward until the middle of 2026 at the soonest, assuming all the commissioners serve out their terms, is changes to the EEOC's strategic plan or the strategic enforcement plan. That requires a vote. So if there's things in that enforcement plan on those enforcement priorities that acting chair Lucas doesn't like, she would have to have the votes to change it. Likewise, revoking new guidance or starting the rulemaking process to initiate new formal guidance, such as the EEOC's regulations on the Pregnant Workers Fairness Act, currently under litigation, all of the formal rulemaking, that requires a vote. Also importantly, data collection, such as pay data. there's been lots of, well, what's going to questions that we've received. What's going to happen with pay data? Is the same thing that we saw at the start of the other Trump, at the first Trump administration going to happen now? Well, the thing is, there is currently no pay data collection active. The EEOC has not initiated its data collection efforts under the Paperwork Reduction Act to start a new cycle of pay data collection, and under those deadlines, they're too late. There is nothing under the Paperwork Reduction Act that will let the EEOC start the process and finish it before the inauguration. So, as a commissioner, Andrea Lucas has expressed grave skepticism about the utility of that first pay data collection and the billions of dollars of costs it would impose on American businesses. So I can't see her moving forward, or the Trump Office of Management and Budget approving that. Now, in Project 2025, which I know President Trump has attempted to distance himself from, Project 2025 talks about eliminating EEO-1 reporting altogether. But eliminating EEO-1 reporting would require the commission to go through this process itself. And it's the current approval for the collection of EEO-1 data goes through November of 2026. Is it possible that that would be revisited after 2026? Yes, but I think it's very premature to say, well, just because that's in Project 2025, we should plan on not having to do that in 2025. Next slide, before I turn it back over to Camille and talk about some other things at the board. So there's I think broad questions here about what resistance an acting chair Lucas could expect from career staff and how she would be able to use the tools of the chair to push through that, or to build coalitions, or to build rapport with career staffs, finding common cause, saying these are the enforcement and litigation efforts we have common cause on and want to continue. And that what kind of leadership she'll bring to the commission in the environment that we're facing. I think that's something that she's thought about. She's been visiting district offices. She's been visiting with career staff across the country, having those conversations, and she's been having those kind of conversations for a while. Let's go to the next slide. I talked briefly about DEI issues. I do want to talk a little bit about AI. I think that leaders in the Trump administration and those close to President Trump see AI as a national security issue. That this is that AI regulation for folks close to President Trump is about American businesses' competitiveness with China, and they're hearing a message loud and clear that regulation, that heavy-handed regulation, threatens to make American businesses less competitive on the global marketplace, and especially with China. And all of that rhetoric, all of that worldview, I think, weighs very heavily against the federal government putting in heavy-handed regulation on employers or others trying to use artificial intelligence. So those instincts, though, that worldview is butting straight up against rhetoric that AI is a free speech issue, and it's a free speech issue that requires government intervention. The rhetoric is that the AI is being developed, designed, trained to be too woke. That tech companies are feeling forced or somehow compelled to train the AI or to have a generative AI outputs that are quote unquote too woke. And this is the rhetoric that some are advancing, suggesting that the government should step in. And I think those instincts about free speech and how free speech intersects with AI butts up against the instincts to not regulate heavily. Which side of the Trump administration and which side of this will prevail? Stay tuned, as they say. Now, in the absence of federal government action on this area, I think the blue states, California, Connecticut, Colorado, Illinois, they feel greater pressure. They feel much greater pressure to put in state regulation. So we've been saying for a while that state regulation of AI is where it's at. So please continue to pay close attention to that. Before I went to the EEOC, I was at the National Labor Relations Board working for Jennifer Abruzzo. So I'm going to also talk a little bit about the NLRB. Let's jump ahead 2 slides, please. So the board has a slightly different leadership structure, and we have some immediate questions about what the Senate will do. So the current NLRB chairman, Lauren McFerrin, her term expires at the end of this year. She's been renominated to serve another term, and her nomination has been paired with a Republican. So there's a package. If the lame duck Senate votes to confirm the package, then we're not looking at a Republican majority on the NLRB for a bit. On the other hand, given how controversial and aggressive she has been, the current NLRB General Counsel, Jennifer Abruzzo, I think I've been saying with a near certainty she's either going to be fired on day 1 or will voluntarily resign at the start of the Trump administration. But here's another theme from me. You heard this from me again. Let's go to the next slide. The majority of what the board does is non-controversial. And I think that's easy to lose sight of when we see all the board and embroiled in all of the controversy about what they've been doing and how they're changing the law and what does it mean. The 5-member NLRB, they adjudicate, they issue opinions, deciding the cases as they come before them, and the majority of the board's adjudications are unanimous and bipartisan. Okay, so the general counsel can shape the agenda by deciding how to issue complaints, what complaints to issue, sole jurisdiction, and argue them, prosecute them, take them before the board. And so when we have the general counsel changing parties, that can change the nature of the cases that are brought before the board, and also changing the nature of those prosecutions. So on the next slide, just a quick taste of things that we expect the board under regular order to revisit under a Republican general counsel and eventually a Republican controlled board, with the votes looking to get that majority to issue to issue these opinions, changing the law, flipping it back, and so arbitration, non-competes, joint employers issues, all CEMEX, all of these issues that the board has been, some would say, controversial on. I think we will see a desire, an effort to undo that. And the big question, I think, in my mind, is are the arguments about the board's unconstitutionality and the president's ability to dismiss board members, and the structural questions over here, does that gain traction in the second Trump administration at the start or midway? And under regular order, we'd have time for the adjudicative process to play out here. And we can expect the pendulum to swing back as a Republican nominated and confirmed general counsel pursues that agenda, and the Republican controlled and majority board eventually issues opinions with that perspective, but not immediately, and subject to budgetary resources and all those limits. And with that, I will turn it back to Camille to talk about the Department of Labor and some other L&E issues. Camille?
Great, thanks so much, Rachel. It's interesting in the EEO space. I just make a couple of comments. One is, on component 2, which you've mentioned and described how it would be very difficult for there to be a new component to pay data collection absent a commission vote. You talked a little bit about the PRA, or the Paperwork Reduction Act. I know some might be thinking, well, but there was some information in the latest strategic plan that talked about it potentially being subject to APA rulemaking. And I just wanted to note that whether it's the PRA or whether it's the APA, that's also going to require a vote. And I think it would be very unlikely that Acting Chair Lucas would actually put that to a vote. So let's look at the Department of Labor for a moment, and let's go maybe 2 slides ahead if we can. One more. There we go. So if you think about, the board members on the NLRB and the commissioners on the EEOC and their respective general counsels, those are all cabinet level, Senate confirmed positions that are for a set term. You heard Rachel describe the fact that, there will be majority Democratic members of both of those entities for the foreseeable future into 2026, unless someone leaves one of those, either the board or the commission. It's a very different structure as it relates to the Department of Labor. So that's what I want to talk to you a little bit about. And I think it makes sense to just step back a second and talk a little bit about the Senate confirmation process, a process that we have seen, seems to always in the headlines be, combined with some amount of drama, I would say. And, just to get a sense, there are 1,200 positions in the presidential administration that require Senate approval. When I think of the Department of Labor and other cabinet appointments, that makes me wonder, well, is it likely then that we're going to see these significant Senate, sort of debates and potentially having people nominated and sit through confirmation proceedings and then not be voted on? And I think it's important to note that defeat of a nominee by the Senate, if it actually gets to the Senate, if someone is nominated and there is a hearing, is very rare. In fact, it only happened once. It was in the Bush administration in 1989, and it related to then a nominee for the Secretary of Defense. So if you look back, it's like, I just think it's good to be grounded a little bit here. If you look back to the last 2 administrations, the current Biden administration, as well as the first Trump administration, what happens, who gets, confirmed within the first 200 days, whether it was the Biden administration or the Trump administration, approximately 120 nominees were all confirmed in those first 200 days. So I mentioned to you, unlike the NLRB and the EEOC, the DOL positions aren't for a set term. So what happens to those individuals who are sitting in those positions today? And I've included some of the key positions on this slide: the Secretary of Labor, or the acting secretary, the Deputy Secretary of Labor, the Solicitor of Labor, and many others that are set forth here. And the answer is, they are viewed as part of the presidential administration, so that when the existing presidential administration is over at noon on January 20th, they leave, has been the tradition throughout, all administrations, as does the president and the vice president. So this isn't a case with the Department of Labor where you would normally see a new president terminating, the acting Secretary of Labor or the solicitor. It's just, those become vacant literally on that day. So let's talk about key presidential appointments that are set forth here. They're really, there's nobody has been nominated. I should start with the beginning. Nobody has been nominated for one of these key presidential appointments in the Department of Labor as of yet. It is likely, in my view, that there will be a Secretary of Labor nominee before January 20th. there has been in other administrations. So I think that is likely. There have been a number of names floated. I've included here 4 names that have been floated as potential Secretary of Labor nominees. I would note to you that of the 4 that are here, Pat Pizzella, Andrew Puzder, and Linda McMahon were all in the first Trump administration in the positions that I have noted here. Or they were nominated. Andrew Puzder, for example, was nominated, but never served, was not confirmed in the position he was nominated for in the first Trump administration. But I note that, I also note that Linda McMahon, who's noted here, was also part of President-elect Trump's re-election campaign. So those are the folks that you see in a lot of the media. There are others, though, and I would not, I am not putting my money necessarily in any one of these individuals. It could be somebody completely new. Although I will note that the second highest position in the Department of Labor is the Deputy Secretary of Labor. And Pat Pizzella served in that position in the Trump administration. So some say he may be one of the leading contenders for the Secretary of Labor position. But again, there has been no information out of the Trump transition team as to who might be nominated. I also note there are a number of other really important, really key positions in the Department of Labor that we will probably not see a nominee for until sometime in the first quarter of 2025. And you can see I've set forth those here. I talked a little bit about the Senate confirmation process. With that, I'm going to go to the next slide if we can. And talk a little bit about wage hour and OFCCP and then OSHA rulemakings and regulatory challenges and where we are today at the Department of Labor. When you think about regulations in a Trump administration, I want us all to recall that one of the first things that President Trump did in his first administration was that he implemented a policy that for every new rule that was promulgated, 2 regulations had to be withdrawn. It was a policy. It wasn't, a law. It wasn't an order of any type, but that was a policy which we heard over and over. He also required a review by all agencies of agency guidance, so that agency guidance that is out there that directs companies to perform certain responsibilities or compliance activity that may be viewed as expanded obligations, expanded from the letter of the law, have been withdrawn or were withdrawn, many of those in the first Trump administration. And, I think there's no question that President Trump is going to direct the departments to review public materials again in light of the last administration to determine if there are any policy agency documents that should be pulled. So what will happen with the wage hour division and OFCCP challenges that exist out there? I've mentioned a few here. One that is subject to a number of different court challenges is the independent contractor rule that was promulgated under President Biden. It's interesting. I just mentioned that President Trump, is not a fan of regulation, and yet it was in the first Trump administration that for the first time ever, the wage hour division of the Department of Labor issued an independent contractor regulation. Through many different types of court challenges and many different presidential actions when President Biden took over in 2021, what we saw was there were many attempts to withdraw that rule, rescind the rule, delay the rule, and it was in flux for many years during the Biden administration. And then the Biden administration ultimately issued its own independent contractor regulation. and withdrew formally by regulation President Trump regulation that had been developed under his administration. There are a number of court challenges underway. I mentioned one here, probably what I think of as the leading litigation in that area with respect to the independent contractor rule, and that's the CWI case that's pending in the Eastern District of Texas. We thought that there would likely be a decision as to whether or not the Biden administration's rule complied with the Administrative Procedure Act and other issues. By now, there has not been. The judges just asked for additional briefing on the issue of the impact or relevancy of the Loper-Bright decision from the Supreme Court. I think that it is very possible that we will get a decision on that before January 20th, though, so I would say stay tuned for that. I also think that it's very likely that, if that decision is positive in terms of the plaintiffs that brought that would reinstate the prior Trump rule, so you wouldn't need new rulemaking. If it doesn't reinstate the rule, but just invalidates the rule that the Biden administration came out with, then I think you could see more rulemaking. You could also see legislative action on the issue of independent contractor status, both on the FLSA as well as in other areas. Let me just mention very briefly the 2024 overtime eligibility rule. There were two significant court challenges to that, the rule that came out under the Biden administration. In the first, which is mentioned here, the court held that the Department of Labor actually can set salary levels. That's in the Mayfield case. But just last Friday, another court held in Texas that the salary levels were so high that were set by the Department of Labor that they violated the APA by making basically the primary duties test irrelevant, and it being basically a litmus test in terms of how much money the individual was paid. As a result, as of that decision, we're back to the pre-July 1, 2023 salary levels of $35,568 annually, or $644 a week, and then back to the pre-July 2023 highly compensated employee level as well, which was $107,432. I will note that even though the Biden administration's rule was enjoined and is no longer in force, that during the first Trump administration, the Department of Labor did increase salary levels. And so I wouldn't say that it's not that the salary level isn't going to be increased or may be increased, but clearly it would do so at, I believe, a much lower number than the numbers we saw in this particular regulation. And I also believe that it would be unlikely that there would be an escalator or automatic increases in terms of COLA increases. Looking at the 2021 final rule, what I would say with respect to that, with respect to the increase in minimum wages for federal contractors, surprisingly, that decision comes out of the Ninth Circuit, and it vacated the rule on the basis that the Biden administration and the president did not have the power to set a minimum wage for all contractors as part of the Federal Property and Administration Services Act. I do not think that you're going to see a new minimum wage under the second Trump administration. Let's go to the next slide. There's a lot we could talk about here in terms of OSHA rulemakings and regulatory challenges. I've mentioned a couple here, the walk-around rule and the proposed heat injury rule. What I would say with respect to the walk-around rule is that it is very likely that the Trump administration will not continue to defend OSHA's walk-around rule, which allows certain third parties the right to participate in OSHA worksite inspections. It's currently under challenge in the Western District of Texas. And I would say some commentators have said, well, but President-elect Trump really courted the union vote, and that was a significant priority for many union leaders. And so stay tuned on that, but I think it would be highly unlikely that the Trump administration would continue to defend that rule. With respect to the proposed heat injury rule, what I would say that the comment period is still open. It's open through December 30th of this year. The comments, though, are going to be reviewed by a new OSHA team under the second Trump administration, and it's unclear what will occur on the federal level, possibly nothing. And I would look then to see if states that have not implemented rules combating heat illness and injury may take that under their wing as well. Let's go to the next slide. Potential impact on OFCCP. It really is unclear what approach the second Trump administration is going to take with respect to the OFCCP, an area where the president has significant power as a result of Executive Order 11246. There may be policy rollbacks. One area may be memo number 1 on pay equity, which required additional pay analysis be shared with the OFCCP, and there were a number of concerns raised and challenges to that memo based on privilege by various companies. Other key policy objectives during the Biden administration that may not be as prioritized under a second Trump administration. There was a focus on parental leave policies that government contractors had, affirmative action requirements for government contractors, and the issues of AI and employment and second chance employment. Second chance employment is something that did have a focus in the first Trump administration, so we may see that as well. I'll just mention in terms of DOL and BLS collaboration, they are working together on following the December 2023 GAO report, which asked that federal agencies come up with one definition, basically, of contingent workers or independent contractors, as opposed to having different parts of the federal government define it differently for different purposes. You may have seen in the last week or two that BLS just came out with statistics regarding the June 2023 contingent workforce. Those did not take into account any of the GAO studies, and some would argue that the definitions used there were very narrow. You had to have been an independent contractor for 1 year or anticipate being one for less than a year to be counted in those statistics. And so I think there's going to be a lot of focus on that, clearly from the Health Committee and Senator Cassidy, who has made a focus throughout this year on getting information to be ready to address some of the obstacles in certainty and consistency in terms of defining somebody as an independent contractor and potentially having certain portable benefits available to them. I would also just mention, obviously, DOL resources and enforcement, not likely to see increases in budget or a rush to fill, especially enforcement personnel openings as a result of the change in administrations. There's probably going to be a significant prioritization of compliance assistance efforts over enforcement. And what I would say, which isn't on the slide, I'll just end with, is comp time has been talked about quite a bit in terms of modernizing the FLSA and whether employers should have the opportunity to provide workers with up to 160 hours of comp time at time and a half in any given year. And that's part of a proposal that's called the Working Families Flexibility Act. And I think we're going to see more of that, perhaps in that form, perhaps in a different form. And with that, I'm going to turn it over to my partner, Leanne Rodriguez, to lead us through what we can see ahead in immigration.
Okay, good afternoon, and in some cases, good morning. Can we advance the slides to the immigration section? Next slide, please. Okay, so in understanding immigration, I think it's always important to highlight that this is um, an area that is very much prone to hyperbole and melodrama, and therefore I think a good time to sort of dig into what we actually know, what we actually expect, and what we don't know. And I think in terms of looking at an incoming Trump administration, we have two important sources of information, and we're going to stay really hard by those sources of information in predicting one, what will be that administration's government philosophy, governing philosophy, and what will it actually do. And those sources of information are the track record of the first Trump administration, and then in the second instance, what's been said either by President-elect Trump or his campaign or his presumptive nominees or appointees for different positions. And so based on those sources of information, we see some predominant themes. One is that the immigration system needs more emphasis on integrity and rule of law. And this is something we really saw in terms of some of the operational changes that were made in the first Trump administration. Second, and this is really from the campaign and really directed at some of the actions taken by the current Biden administration, is that humanitarian immigration programs and policies have been overutilized in a manner contrary to both law and the national interest. The third, and probably the one where most voters were focused, is that the southwest U.S. border is in a state of crisis, and that the federal government has really lost control and not dedicated adequate resources to that. The next is that the removal of authorized persons is a top priority. And finally, but not to be discounted at all, especially for this group, which I'm sure is predominated by employers, is that high-skilled immigration should be limited to the most skilled, educated, and talented, and not operate to displace available and qualified U.S. workers. And here I emphasize that the campaign has actually said very little about this particular topic. However, it was certainly a theme that informed both the manner in which adjudications were conducted in the first Trump administration, and two, some of the legislative initiatives that were explored during the first Trump administration. And so from that point of departure, some things we can expect to see. One is the reversal of the Biden era humanitarian parole programs, in particular, the ones that provided pathways to admission to the US for Ukrainians, for Cubans, Venezuelans, Haitians, and Nicaraguans, to a significant curtailment of entry by either asylum seekers or parole seekers, meaning permission to enter the U.S. through other than the traditional asylum path at the southwest U.S. border, efforts to curtail other humanitarian relief pathways, such as the Deferred Action for Childhood Arrivals program, the Temporary Protected Status program, acceleration of deportation activity. There's actually been a lot of news and also social media posts by President-elect Trump about that, actually just this morning. Expansion of worksite enforcement, and we'll talk a little bit about what that could mean. And then stricter approaches to immigration benefit processing. So next slide, please. And so what we know, and I'm certainly a believer in the idea that personnel is policy. What we know is also based on who we see either destined to become part of the incoming administration or anticipated to become part of the incoming administration. Most significant for some of the issues that I raised is the appointment of Tom Homan, who was a senior official in Immigration and Customs Enforcement in the Department of Homeland Security through the Obama administration. I worked directly with Tom, and who played an on-again, off-again role in the first Trump administration, and is also known very well as a commentator on immigration enforcement issues on Fox News and other media outlets. He is certainly somebody who knows the system very well and is a very, very capable manager of that system. And therefore, I think, for my money, the most important person to watch in terms of what's going to be happening with immigration enforcement in the incoming administration. Then we have Kristi Noem, the current governor of South Dakota, who is anticipated to be nominated as the Secretary of Homeland Security. She has certainly made public statements about the need to address what many characterize as irregular immigration, either in the form of illegal entry or asylum seeking, and also had sent her National Guard down to the southern border, southwest U.S. border during the Trump administration. Outside of that, not an individual who has really had a lot of, has said a whole lot about immigration policy in the past. And finally, Stephen Miller, very well known from the first Trump term. He's obviously going to have a much broader portfolio than just immigration as the deputy chief of staff. And so while he certainly will continue to be an influential thinker, it remains to be seen what his operational role will be, especially in light of Tom Homan's role as the quote border czar. Next slide, please. So what that means, starting to talk in specifics now. In terms of enforcement activities, we can anticipate either a curtailment of humanitarian entry in particular by asylum seekers through the southwest border. Important to note that there has already been some level of curtailment by the current Biden administration, but there could also be a more wholesale closure, allowing people to lodge their asylum claims and then wait in Mexico or elsewhere, as was the case during the for sure during the first Trump administration, and to a certain degree during the current administration as well. There is also promised a lot of interior enforcement, and this is something that will be consequential to employers. There have been specific promises of worksite raids. There were similar such promises made during the first Trump administration. There was one particular raid in Alabama that commanded a lot of national attention. But at the end of the day, there were certainly expanded fraud investigations, I-9 inspections, but not the sort of dramatic worksite raids that many came to expect. Whether a much higher level of activity will occur in this administration, again, remains to be seen. There are also going to be efforts to curtail a number of what many have been calling liminal statuses. In other words, not traditional immigration benefits, but rather various sorts of permission to remain in the United States, either pending an asylum adjudication or as a temporary matter for various humanitarian reasons. So this extends to DACA, temporary protected status, these humanitarian parole programs I mentioned earlier on asylum seekers. And it's estimated that there are about 3.3 million people in this combination of statuses. And any partial or more complete termination of these statuses could actually have significant workforce impact. These tend to be younger, employment-aged people, some of them raised and educated in the United States. And the degree to which these are implemented will really determine how impactful this will be for the United States. And finally, next slide, please. Just a quick note of employment-based immigration. So a number of you may employ individuals in H-1B status, specialty occupation, or L, intercompany transfer status, or may have people that you sponsor for green cards. Much of this will be the same as it was during the first Trump administration. This is the point where I hasten to point out that even during the first Trump administration, the fact is that the levels of H-1B utilization were not particularly different than they were either in the Obama or Biden administrations. And so while there may be increased burdens of processing, at the same time, cease to exist. With that, however, there are one particular area that could be potentially consequential, and that is the work authorization for spouses of individuals pending adjustment of status, pending their green cards. And there could be some significant efforts to eliminate the access, as there were during the first Trump administration, to eliminate access to work authorizations for those individuals. More likely, however, given what had been successful legal challenges to sort those reductions, more likely a change in the process that will certainly make it take longer and potentially reduce the number of people eligible without necessarily fully eliminating those employment authorizations. Lots more to watch here, but did want to share some of the highlights with folks, and as always, happy to answer questions. Thank you, and with that, I'll turn it back to our moderator, Camille.
And before, this is Rachel, before Camille comes in, or if we need Camille here, I have the CLE code for everyone. The CLE code, and you see the QR there is SS, as in Seyfarth Shaw, 6655. Again, the CLE code is SS 6655. Camille?
Great. Thank you so much, Rachel and Leon. We appreciate the opportunity to share these insights with you. We have also put together, along with others at Seyfarth, a policy briefing report that is also available, and we encourage you to take a look at that for more in-depth insights. And of course, reach out to us if you have any questions. Thank you, and we all hope you have a great rest of your day.